Hello everyone, this is Madhuri, Associate Professor, Department of Law, Padmavati University. Another chapter we can see in labor law is the Maternity Benefit Act 1961. Here this act gives you a definition of that is a beneficial piece of a legislation which has been given object to ensure the security of the tenure of a working woman. This benefit is a benefit which has been given to the mothers to be or mothers of the newborn with fully paid leave from employment and from along other benefits before and after delivery of the child with the motive to facilitate the woman in taking care of a child. Mamata versus Employees State Insurance Corporation 2014 is a famous case where you can see number of points what we can cover in this. It is held that a given birth and taking care of a child is covered under the fundamental rights of a child and the woman and hence an employee shall be held liable for the paid maternity benefits. Applicability, if you want to see the scope of section 2(1) class A, the act applies to the establishment includes factories, plantations, mines, shops. Establishments covers under ambit of law having 10 or more employees. This includes a private sector as well. So another case was Thomas John versus Labor Officer 2014. Here the firm with only 3 employees will not be covered under this act. Eligibilities, we can see section 5(2) of the act. It is mentioned that women to be eligible at the maternity benefits under the act has to be employed in an establishment not less than 80 days in the 12 months immediately preceding the expected delivery of a woman. The period has been reduced to 160 days to 80 days by the virtue of 2017 amendment. This period of 80 days does not apply to any woman who has immigrated to the state of Assam and was pregnant during the immigration. So Glenbrook versus a plantation office 2012 case. Here the daily wage workers are entitled maternity benefits under the scope of the act. And Arya Government Girls Senior School 2017 is another things. Maternity benefits was fully paid leave cannot be denied to contractual employees too. This was decision of the Honorable Central Administrative Tribunal which has been taken there. So duration of the leave will comes under the particular way of in different cases like 26 weeks of a woman up to 2 surviving children. The woman at a discretion can take up to 8 weeks of the maternity leave before the delivery and remaining 18 weeks after delivery. 12 weeks will be taken according to that woman already having 2 or more children. And the woman at the discretion can take up to 6 weeks of a leave for delivery and the remaining 6 weeks after delivery and the remaining 6 weeks after delivery of a child. And 12 weeks of a particular woman adopted a child age of 3 months from the date of handing over a child. 12 weeks for the commission of mothers, commissioning mother and a mother who puts her in another way, surrogate from day of an handover of a child. 6 weeks for the particular way where we can see a miscarriage from the date of termination of pregnancy on the production proof as mentioned in section 6. Further, a woman has gone through a miscarriage but has not worked in establishment for 160 days in preceding 12 months can also claim the leave for the miscarriage as decided in this case. Management of Kalyar Estate, Jayashri State Industry Ltd versus Chief Inspector Plantation 1998 case we can refer. 2 weeks here who has gone through the tubectomy operation family planning from the date of an operation on production of proof under ambit section 9A. 1 month can be given to the woman who suffer illness arising out of pregnancy, miscarriage, premature birth, delivery, medical terminations or the tubectomy along with the wages of a particular maternity benefits. Kinds of works what we can see cannot be employed to complete the other following nature under the ambit section of 4. Works of onerous natures and works involves long hours of standing also. So duties of an employee for maternity benefits you can see section 5(2). Maternity Benefit Act 1961 also gives you a particular way of 80 days of the 12 months also can be taken. So 10 weeks before the date of an expected delivery will be taken. She should also give a written notice to the employers among 7 weeks before the date of her delivery that will be absent before the particular delivery too. Legal obligations of this particular act we can see no employer shall knowingly employ a woman in establishment during 6 weeks following of a particular date. No woman shall work in any establishment during the 6 months of her immediate date, and unlawful of her employee or a discharge dispense also should be taken, and the gross misconduct an employee in writing can communicate about depriving such benefits.